So the other day, Jay Embry made this claim.
Why else would she not want to be involved in the trial? Why else would she be lawyered up?
He was talking about Dylan. And right after that, several of his followers started repeating the nonsense that Dylan and Bethany were trying to get out of testifying at trial. Well, that is absolutely false. He's getting several things confused. First of all, lawyering up is what anybody would do. Okay, if you've survived a crime, if you're being questioned by police. Now, normal traffic stops, obviously, you're not going to have a lawyer or lawyer up, but any other time that law enforcement wants to talk to you about something, you should always have a lawyer present. And that doesn't matter whether you're innocent or guilty. Always have a lawyer present because they can twist your words around. And former cops have even lectured at college law classes, telling them this is why you always advise someone to have a lawyer when they talk to police. Let's say your neighbor gets killed. Officer comes by, says, "Hey, what do you know about your neighbor? Someone murdered him." And you just say something like, "Oh, I'm not surprised. Everybody hated him." Next thing you know, you're the number one suspect because they're going to twist that and say you hated them. Never talk to police that is part of an investigation without a lawyer present. So, of course, Dylan and Bethany got lawyers. They were being interrogated by law enforcement. They're going to be testifying at trial. Now, neither Dylan or Bethany has said they won't testify at trial. Neither have said they are scared to come back. In fact, Dylan has been back in Moscow since then to visit friends. So they're not scared. I think where people are getting things twisted is when Bethany was subpoenaed back in the spring of 2023. So let's have a little refresher on that. Okay, so here's what kind of started a lot of these rumors, and that was the affidavit in support of a motion for out-of-state service, and it was the affidavit filed by Richard Bethany. And this was back in the spring of 2023. And it was on behalf of Ann Taylor, because remember, Ann was floating out there that she thinks Bethany may have had exculpatory evidence. And so it talks in here about how her bedroom was on the first floor. She was interviewed by police on several occasions. She disclosed things that she heard and saw. She was present at the home when police were called, arrived on scene, and discovered the crime. And it says, during the course of my investigation, it became known to me that Bethany Funk has information material to the charges against Mr. Koberger. Portions of information Miss Funk has is exculpatory to the defendant. Miss Funk's information is unique to her experiences and cannot be provided by another witness. Bethany Funk resides in the state of Nevada, and it is necessary to subpoena this witness because the witness's testimony is material and necessary to this case. So something I want to point out is exculpatory. What the defense thinks may be exculpatory may not be. What the prosecution thinks may not be exculpatory may be, and vice versa. It's actually all up to the attorneys and their views as to what they think is exculpatory and what isn't. Now, another thing is, in Idaho, grand juries must present exculpatory evidence. So if Bethany truly had anything exculpatory, as Mr. Bethany believed, then Bethany's testimony, when shown to the grand jury, must not have been very compelling towards pointing at innocence of Koberger, because they still chose to indict. Now, I understand a grand jury is just probable cause and not beyond reasonable doubt, but because exculpatory has to be presented to the grand jury, that says whatever they felt Bethany had was presented. And apparently the grand jurors did not feel it was necessarily exculpatory. Of course, we won't find out until trial. It could be something as little as them using her to impeach Dylan as an eyewitness. They could have had her say something to the effect of, like, yes, Dylan was out drinking that night or doing drugs that night, etc. Just maybe trying to impeach the other witness. But again, we won't know until trial. But let's continue with our refresher on these documents. And as we continue with the documents, you can see that this was the motion that Anne had filed. So ex parte motion for certificate to secure the attendance of an out-of-state witness. And then Megan Marshall signed that certificate and sent it to Nevada. Now, one key point in this that people keep misinterpreting is number 6, where it says, under the laws of the state of Idaho, if Bethany Funk comes into this state in obedience of a summons requiring her presence at this hearing, she will not be subject to arrest or service of any process relating to matters that arose before she entered the state under summons. That is boilerplate. That does not mean Bethany had any sort of criminal issues that would need to be set aside for her to come back into Idaho. That is copy and paste that occurs on every single one of these certificates. So people are reading way too much into it. Boilerplate language doesn't indicate anything one way or another. And then you can see the second page where it was signed by Megan Marshall back on 3/24. And then you can see where it was received on the 4th day of April and recognized by the state of Nevada. So Judge Evelyn Grosnick, the interim Washoe County public defender. So that's who that request for foreign subpoena went to. And then next we have the response from Bethany's attorney, Kellyanne Valoria, and it's the motion to quash the foreign subpoena. And in that memorandum to quash the subpoena, she talks about how it's an ex parte request, and that she also pointed out that they misspelled Bethany's name repeatedly, which not a good look by Ann Taylor. But it says that they're claiming that she has information material to the charges against Mr. Koberger, which was misspelled, and also, and that portions of information Miss Funk has is exculpatory to the defendant. Her attorney says these statements are conclusory, without support, and there is no further information or detail pertaining to the substance of the testimony, its materiality, or the alleged exculpatory information of Miss Funk, or why it would be entertained at a preliminary hearing. Moreover, the subpoena was issued by the clerk of the court without a hearing. No hearing has been set for Miss Funk to address these concerns, so the motion follows. Basically, that's saying that claiming she has exculpatory seems to be without merit, and also the preliminary hearing is not usually the venue for that. The trial would be. And she states that the court should quash the subpoena issued because of the following concerns. It says specifically, NRS 174.415 requires the court to fix a time and place for a hearing before it can issue any order directing testimony in another state. This hearing is necessary to provide a venue where the judge determines that the witness is material and necessary, and that it will not cause undue hardship to the witness to be compelled to attend and testify in the prosecution or a grand jury investigation in the other state, and that the laws of the state in which the prosecution is pending or grand jury investigation has commenced or is about to commence. So basically, she can't be compelled to testify in another state without a hearing in the state that she lives in. It says, once that procedure is followed and that burden is met, then and only then shall the judge issue a summons with a copy of the certificate attached, directing the witness to attend and testify in the court where the prosecution is pending, or where a grand jury investigation is commenced or is about to commence at a time and place specified in the summons. Moreover, there is no authority for an Idaho criminal defendant to summon a Nevada witness to Idaho for a preliminary hearing. And that is in bold. And preliminary hearings usually do not require a witness to be there. They have summary witnesses. That mainly is police officers, FBI agents, the people that took the statements, and they will testify on behalf of the person. Hearsay is allowed at preliminary hearings. So they will read the statement by the witness. So Bethany's statement would just have been read at a preliminary hearing by law enforcement. There's no reason for her to attend in person at all. And she goes on to cite some more Nevada laws about somebody having to attend from out of state. And it says, importantly here, there is no certification by any judge of any court of record in any state, Nevada or Idaho, that clearly states that Bethany Grace Funk is a material witness in such a prosecution or grand jury investigation. And then her conclusion is that the foreign subpoena was improperly issued. There was no component of the statutes followed in its issuing, and the court should quash the subpoena issued to Miss Funk now. And this was the declaration of her attorney. And then the conclusion of that was that the judge released Funk from the subpoena on April 26th, after the prosecution and the defense said in court documents that Bethany agreed to be interviewed by defense counsel in Reno, Nevada. So as you can see, that was only because a witness should not have to come testify at a preliminary hearing, nor should they have to come testify for the defense at a preliminary if they don't want to. Normally at a preliminary, the law enforcement officer that took their statement will read their statement at the preliminary hearing. So I don't blame Bethany for not wanting to come back for the preliminary when really she only needs to be present at the trial. And especially I don't blame her for not wanting to help the defense attorney for the person that's alleged to have killed her friends. I certainly wouldn't want to testify on behalf of the defendant that's been charged with killing my friends. So this is not indicative of those two fighting coming up for the trial. There's actually no indication that either one of them is not going to testify. So I wish people would stop sensationalizing this and saying things that have never come out of these girls' mouths.